Tonight, the drama continues in Georgia as rapper Young Thug's criminal trial gets thrown into chaos. Jeffrey Lamar Williams, a.k.a. Young Thug, is charged with violating Georgia's organized crime laws. Prosecutors accuse William and 26 others of being members of a criminal street gang named Young Slime Life, or YSL. We showed you last week the moment that Judge Earl Glanville appeared to be caught lying about a secret meeting he had with prosecutors and one of the prosecution's witnesses. And instead of fessing up, Glanville demanded how Young Thug's defense attorney Brian Steele found out about it in the first place.
Can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea
I have an
may be
idea
wrong.
how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to... Listen, I told you the first time. You spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness. You're not supposed to have communication with a witness who's been sworn.
Well, I'm going to hold you in contempt.
When Steele refused to give up his source, Glanville held Steele in criminal contempt and ordered him to jail. Now, the Georgia Supreme Court put a pause on that jail order, and this week, Steele filed a motion demanding the judge recuse himself from the case entirely, accusing Glanville of obstructing justice. And that's no small accusation to make against a sitting judge. Glanville has to follow certain rules when he's deciding whether he's going to step aside. He looks at whether the request is timely, and if everything he's accused of doing in the motion is true, he has to assume the facts alleged are true. Would that require his recusal? Now, Steele says Glanville participated in coercing a state witness behind closed doors without the defendant or his lawyers present. And he says the judge essentially became a member of the prosecution team, assisting them with inducing a witness to testify against the defendant. Now, if that's true, which is what he's supposed to assume in order to pass the recusal decision off to another neutral judge, he should recuse. But here's how the judge came down.
Bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time.
Steele stood up after that to let the judge know that Steele plans on calling him as a witness, as well as the prosecutors who are charging his client. How is that going to work with the judge presiding over the trial?
I've added this court to the witness list. I plan on calling the court as a witness in the trial. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams.
Now, Steele can ask a higher court to review Glanville's decision through what's called a writ of mandamus. What's a writ of mandamus? Well, it's not good. No judge wants to get mandamused. Mandamus is a court order to a government official or a lower court judge saying you abused your discretion, you got something absolutely wrong, and you're hereby commanded to fix it. Here, Steele's attorneys would call for a writ arguing Glanville is blatantly violating Williams' constitutional right to due process, not only meeting secretly with prosecutors to coerce a witness, but also now refusing to recuse.